they choose. Um, I'm grateful for the opportunity to be here. Uh, Years ago I was with Northwest Met. Haven't been part of it for a while, um, mostly due to the shift in my job responsibilities. My name is Nate Wise. I'm from BYU, Idaho. I started in education technology back uh, in K-12, really, is where I started with that, in a high school in Montana, helping them, figure out that internet thing. So technology changes was something that was new and exciting at the time. Um, the Y2K scare was something they wanted to have somebody on staff to do that. So they grabbed the Spanish teacher, because who better to help with the Y2K thing than the guy that taught Spanish. I later got my master's degree in education technology and went on and I got a job at BYU, Idaho, which was Rick's College before then. And have been there for the last 15 years. Started there in academic technology, came to Northwest Met, and when it was just Idaho, Washington, and Oregon, and it has really grown since then. And so I'm just impressed with the growth and how many people that there are at this conference, and I appreciate you coming and attending this part of it with me. But that's where I'm at. A lot of my time, and how did I get to the Office of Compliance and Legal Affairs from education technology? It really came from licensing, copyright, and doing policy work in the intellectual property policy. And I went back and also got my paralegal degree. So I'm not the general counsel. I work with general counsel in their office as the paralegal and as the chief intellectual property officer at BYU, Idaho. And so it's my duty there to kind of advise the faculty and administration and educational technologists in those areas where copyright and the law intersect, and compliance issues that come up as we talk about the different uses of media and other third-party content that comes into play there, and the other issues along those lines, and as well as what we are creating, and making sure that what we are creating and putting out meets the requirements of the law. So that's what my role on campus is and the things that I do. So just kind of to give a basic overview of copyright law and what it is, it starts in the Constitution. The founders felt like we needed to have a protection for creators and inventors, and so they put in Article 8, or Article 1, Clause 8, about Congress having the power to promote progress of science and useful arts. That's kind of the catchphrase for copyright. Progress of science and useful arts isn't just science as we think about science now, but the whole process of learning and creation, invention, and those kind of things. So that they provide this monopoly as an incentive for creators to create content, to build culture, and be able to learn. And it helps us as a society be not just consumers, but producers. And that's kind of where a lot of this friction begins. Where do we draw the line between consumption and production? And especially when we start thinking about AI and what it introduces into this concept of copyright. So copyright, basically, the definition is legal protection granted to creators, such as text, images, music, or code that are fixed in a tangible form. There's also other things, choreography, architecture, that are also protected forms of works that are out there. So it's automatic. As soon as we take a picture, if you've ever taken a selfie, you're a copyright holder. All rights reserved to you. But to do anything with that all rights reserved copyright, you have to register it, or you don't really have any teeth in that. Part of one of the treaties that the U.S. is a party to requires that everybody have copyright protection in whatever country they're in. So only the citizens of the United States have to register their work. So there's a little bit of disparity there, which will come into play as we talk about AI and offshore creators and things like that as well. So, but the key facts there, registration is optional and it lasts a long time. So anything that gets created lasts for the lifetime of the author plus an additional 70 years. So that's the default, that's the basic. And if it's a work for hire, it's 120 years from when it's created, or 95 years from when it's published, so whichever is shorter there. So anything that I do for BYU Idaho has a lifespan of 95 years once I put it out there. And so it lasts a long time. So a lot of the stuff that AI has gobbled up is copyrighted, and that's what it's trained on. And so we'll talk about some of these things, but before we get there, we're going to talk about one of our first little sideshow is this monkey business. And I don't know how many have heard of this case. David Slater is the photographer who went to Indonesia to photograph monkeys. And while he was there, he realized these monkeys are pretty curious critters. And so he set a few cameras out and just to see what the monkeys would do. And sure enough, the monkeys took selfies, and he thought, well, this is great. He's going to publish a coffee table book on these, and then these pictures started showing up on Wikipedia, and he's like, wait a second, that's my copyright. I created these pictures. And people started to argue, saying, no, you didn't. The monkey created these pictures. The monkey was the one taking it. So if you hand somebody your phone at the wedding, you know, they're the photographer, even if it was your own phone, and they take the picture for you, technically they own the copyright in that. And so that's what they were arguing, that the monkey was the creator. So PETA filed a lawsuit in favor as a friend of the court, because the monkey couldn't file the lawsuit. So PETA filed the lawsuit in favor of him trying to claim the copyright on his selfies. And the judge rolled his eyes and says, not really. So basically the compendium of copyright says, you gotta be a human. So animals can't hold copyright. And so that's kind of where that went. So his famous pictures went down as public domain, which means not just publicly accessible, but publicly owned. So he can't own them, the monkey can't own them, PETA can't own them, but anybody and nobody owns them, right? So it's public domain in that sense. So everybody can have them, same as an elephant painting a portrait. The Copyright Office mentions that, you know, in order to have a copyright, you have to have a minimal modicum of creativity, and that has to be fixed in a tangible medium, and that gives you a copyright. Yeah. It's now public domain, so our friend Mickey Mouse a couple years ago fell into the public domain, right? Steamboat Willie, at least that version. And so Disney tries to make it a trademark by using that clip as, you know, you can hear the whistling song and Mickey, you know, and so if you were going to create a video with Steamboat Willie and try to make it look like a Disney video, that's when you're going to run into issues, and they're going to claim that it's a trademark dilution. But you can use Steamboat Willie, and people have, and I know there's already a horror film about Steamboat Willie, you know, doing whatever a horror film Steamboat Willie would do. But yeah, so public domain is the expiration of copyright. So, and every year there's something new that comes into it. And so come January 1st, we'll get a whole new crop of exciting things from 1931. So buckle up, because here it comes. Yeah. So Popeye and Olive. There's Betty Boop. Just this last year was one of those in her original form, which was a little bit odd. It's a little bit odd, anyways. But I digress. So the public domain is important part of this, as well as who gets to create it. So I'm sure we can draw the parallels from Naruto the monkey being not a human and creating something and not being eligible of copyright to this image. Anybody familiar with this? This is Stephen Thaler's first AI creation. He created a program a computer that would spit out images. So this was the first images, and he submitted something to the Copyright Office wanting to copyright his or its image, right? And he put the AI machine as the original creator. So what did the Copyright Office do? They said no. And so he decided to sue the Copyright Office and took them to court, actually, to say, hey, this creation was fully done by AI. It should have copyright because I built it and it decided and it created. Can it do it? The district court said, no, it can't. He appealed it and said, what if it's a work for hire? What if I sort of hired this computer to do this work for me? Can it count as an author then? And the court still said no. And he actually took it to the Supreme Court. And just this year, the Supreme Court denied to hear the case. So the Copyright Office edict, right, still stands, not copyrightable. If the machine did it, you can't get a copyright. If the machine was fully the rights or the creator, and there was not additional input there. He did the same thing to the Patent and Trademark Office about an invention. The same machine, he had it invent something. And so he went the way of the patent, trying to get a patent that was not human created. In the Patent Office, same thing. You have to be a human to do it. But Thaler is kind of famous for pushing those bounds. And the Supreme Court not hearing the case doesn't mean it really changes the case. It just solidifies what the lower courts had decided. So it's not a Supreme Court precedent, but rather the lower court precedent that kind of establishes that. Mm-hmm. Yeah, so that's it. It depends. The question was, if you use AI to create a photograph or an image, who owns the copyright? And right now, according to the laws, nobody owns it, so it's not copyrightable. And we'll talk a little bit more about that because there's some different stuff here. This is a book, a graphic novel that was created by Chris Castanova. And she also created this book, but used Midjourney to do it. As you can see, it shows Midjourney was Castanova and Midjourney was the author. And the Copyright Office says, no. At first, they gave her a copyright on it because they didn't realize what Midjourney was, or who knows. But then they backpedaled quickly and said, we're canceling your registration because apparently you didn't create all of these images that were in this book. And here's a couple other examples of it. They had done some prompting and some changes, and so they argued that they did enough prompting that maybe, with the prompts they did, it would help solidify the ownership, that their creativity was involved. But it was still the machine itself that was making those creative choices, and the Copyright Office said, no, you still can't. We'll give you copyright on the text if you wrote the text, and that's they didn't really argue that they had or hadn't written the text. But what they gave them copyright on was the selection and the arrangement of the images. So the order, the storyboard, so to speak, of the book is protected but the images themselves are, again, anybody's images. We had a question. Yeah. Yeah, so yeah, it can. Again, I hate to use a lawyer answer, but it depends, right? And that's what about adding additions or changes? So a few years ago, Jason Allen created a digital artwork that the basis of which was created by AI. And this is the image here he started with, prompting it for several iterations, and ends up with this one. I don't know if you can see it as well there, but there's a little bit more detail to it. And so he also wanted to get copyright on this because he won the digital photography or the digital art prize at the state fair in Colorado. And there were plenty of people that were upset at that because did he create it? Was he the creator, or was it the robots, right? Was it, how much was his own thing? And that's, here's the name of the work, Théâtre de Opéra Spatiale, whatever the French is. I apologize for any French speakers, but, but a space opera theater. But even though he had done 624 revisions on this, again, they said it was de minimis because the underlying image, despite his additions, was not his own. Now, the difference being with your question, if you're just enhancing a photograph or doing something, was that photograph your own, your lighting, and then you're adding, making those creative decisions, right? And if that's the case, then yeah, you can use AI as a tool. It's not making those choices, you're applying those choices, and it's the means whereby. So that's probably the takeaway is how much human authorship. Am I in the driver's seat of the creativity, or am I being passive and doing that? Same as writing and what we're telling our students, what they can and can't do. You can use it as a tool, but don't hand them the keys. Yeah, you can still keep the money. That's why he was wanting to copyright it to protect other people from selling it and keeping the money. But because it's nobody's, anybody can sell it. And so what does that do to your market value on that? It's not much, right? Because, but it really kind of depends on what tools we're using.
So if you're working with an image, but you're not making deliberate decisions on lighting stuff, that's just still AI.
Yeah.
You know,
Yeah,
make it better,
enhance this,
whatever.
right.
Is that still?
The underlying image would be protected. So if I take something and I use the Gemini tools on Google Photos and say, fix this, it'll fix it, but you only have the copyright in the underlying image and not the enhancements that are there. But, you know, that's the technical thing. So is anybody, including the Copyright Office, going to know whether the image that you submit or register was made with AI? They want you to disclose what was AI and what wasn't. But again, it comes back to, are you disclosing that, or are you going to cut yourself out of potential market for doing so? So it kind of is a two-edged sword there. Again, back to the registration requirement. If someone else from another country does the same thing, they don't have to register it. They can still sue for it, and they've not disclosed how it was created. So there's some nuance in that, and especially where it's new and we're not sure where that goes. So the takeaway is AI generated artwork is not copyrightable, and so there is a void of ownership, but it kind of depends on how much creativity that one has put into the work, and the creative choices. So it's the creativity. If you remember from how copyright works, you got to have some creativity and originality there, And if you're passing that off, then it just isn't copyrightable. A portion of it can be like there is AI created works that were, it was a collage artist that said, give me a piece of cheese, give me some noodles in the shape of this woman's face, and he combined and put them together to be able to make an image, but he created the image out of the other images. So similar to what any other collage would be. So this AI copyright conundrum triggered the Copyright Office to say, we've got to give some direction to legislatures, to judges, and to update things. So they put out what they call a Notice of Inquiry, an NOI. And that was in 2023 when copyright was a little bit newer. And they figured they would get some comments and that. And they usually get a few hundred comments on these kind of things. This one came back with over 13,000 comments of things that people were concerned about in copyright and AI and how it all works. So it was a heavy lift for them to have to go through each of those comments and try to put them together and decide what are the issues that are there. So the biggest issues there, those 6 that are the closest to the center, and they came out with a report, and that's kind of where I got the Sideshow idea, because it's kind of a 3-ring circus of copyright. So their report came out in 3 different sections. The first section was an easy win for them. It was on digital replicas. So it's super easy to create a digital replica. There's even AI companies out there that's their deal. They want to create an avatar for you that is the talking head that moves, and that 11 Labs, right, is one of those, does the audio and video. But then there's all kinds of stuff. All it takes is for you to pull up your Instagram feed and you'll see the slop that's out there that's been created by AI. And so there is some danger in the digital replicas. Their second one was on copyrightability, which we kind of talked about with the monkey selfie and Fowler's decision on, human authorship is required. And the third is on the training, and that's probably the biggest. We're kind of in the middle of the beginning on that one and trying to decide that. So the first one, again, here's some of their basic things that they found in this first report that was released, that it's a new law is needed because not all the states have laws on publicity, right? It varies by state. California's got strong publicity laws. New York's got strong publicity laws for obvious reasons. But the state of Idaho doesn't have any at all. So there's no right of publicity. I can't go and sue anybody for using my name and likeness unless I have some NIL contract, right, with a college or university to be able to control that. But the state itself, there's no common law for rights of publicity. And so it kind of depends on your state and where that's at. So they're recommending that that a federal law should be made to provide the widest protection for that kind of thing. And there's the No Fakes Act that was put out in 2025, at least a bill introduced in Congress, but we know how fast Congress works. They're a little bit slower than the courts, and the courts are not fast either. So, it depends on the constituency and how important the congressmen think that this is in a midterm election. And right now, not too for them unless they show up in attack ads or things like that. So then, yeah, let's make some improvements and disclosures for that kind of thing. And so their assumption was Congress should act on this. And so that was the first report. And the next report took a little bit longer, and these are just examples of other rights of publicity and people that are worried. Anybody heard of Norwood? Right? She's the actress, quote unquote, air quotes, that is an AI actress. And so Hollywood pushed back on that idea of having somebody that was completely AI acting in movies, but yet the perfect stand-in for stunts or things like that. So it's there, Matthew McConaughey trying to trademark, because copyright wasn't there, but can he trademark his catchphrases, all right, or whatever he says, right? So, so trying to do those kind of things to protect his brand, so to speak, and his creativity. So they're looking for ways to avoid that. The next, the Ring 2, copyrightability we talked about, right? So existing principles of the law are sufficient, and that's what they said. It's copyright law is supposed to be technology agnostic and should be able to handle the things that come, whether it's AI or some new thing that creates works. I don't know. Until the law changes, that's kind of where they're at. But obviously the law is way behind technology, as is the case typically, right? So just because you can do something doesn't mean you should, but it also doesn't mean that it's not legal. And so because it's kind of the great unknown, that's kind of where we're at. And now, like I said, we're kind of at the beginning of the middle here, where we're trying to decide on the outputs and the AI training. So the AI training implicates copyright, and the fair use doctrine needs to be decided. And there's been cases that have gone both ways. Cases that they said, oh yeah, it's fair use. Then there's other cases like the Anthropic settlement for $1.5 billion, with 92% of those people that opted into the case. So 92% of case people saying, I want my cut from this settlement, and they decided that it's about $3,100 per author or whoever had written books. I have a friend that's an author that his books were found in that, and he has several. I think he's number 34 on the Amazon list of authors, and he had several of his books, so he's definitely part of that class and is happy to get something from his works that were gobbled up in that. So was it fair use? The judge said it was fair use. Well, except for that shadow library they used in training, because it wasn't legally acquired, and often that's the difference. It needs to be legally acquired to be able to leverage your fair use, and where that one wasn't, they were able to do and decide, you know, what are those 4 factors in fair use. So the 4 factors, typically, I don't know if we go into it, but the 4 factors are the purpose of the use, the amount that it's used, the impact it has on the market or the potential market, and the nature of the copyrighted work, whether it's something that's super creative or if it's something that's more factual, has maybe a thinner copyright. But as you notice, the acronyms PAIN help you to remember those: purpose, impact, the amount that's used, and the nature of the work. So the courts need to decide, is this or is this not a fair use? And so there's a few cases that have come up, actually, since May 13th, when this site, it's chatgtpisEatingtheworld.com. If you're interested in how many copyright cases there are, there's over 110. There's 111, I think, currently, and new ones that are added. When I first started looking at this, there was in the 60s, and now it's doubled and jumped. And these are the biggest defendants, obviously the big copyright holders, and so they're the ones that are being sued over the different categories of works that are there. And is it fair use? And again, it comes back to the outputs and to the training, that these companies had created and do that. So one of the latest fair use cases was the Goldsmith versus Warhol. So the Andy Warhol Foundation v. Goldsmith. Goldsmith was the photographer. She took the photo of this guy our friend Prince, right? When he was just beginning in the 80s. And Andy Warhol, at the time, he licensed with actually it was Vanity Fair that licensed with Goldsmith because they wanted Andy Warhol to create a cover for a Vanity Fair magazine. And so she licensed it for $1,000 or $750, I think it was, to Vanity Fair to have Andy Warhol create a magazine cover. He proceeded then to make, I think, 16 or 18 different silk screens of prints in this way and used them, because he's an attribution artist. He'll take something and create his own style, so to speak, of that. And this was all fine and good until, Prince died, and Vanity Fair then wanted another magazine cover. So did they go back to Lynn Goldsmith and say, hey, I want a picture of Prince for his memorial issue of Vanity Fair? Nah, they went back to the Goldsmith family, the Warhol family, the estate, and said, for $10,000, let's use the orange Prince or the purple Prince. I don't remember. He had different colors, but the orange Prince is the one from the case. And so they used that one, paid them $10,000, ran with the magazine cover with that on there. And when Lynn Goldsmith was cut out of the deal, she's like, I'm going to sue him for copyright infringement. She felt wronged, and actually the Warhol Foundation sued her for summary judgment because they wanted the judge to say it was fair use, it was fine, it was their content. And so she had to defend herself basically as the copyright holder to say, no, it's not just fair use. This is mine. I own it. I should have some say in how it's used. Now, under U.S. copyright law, as we'll talk about here in a second, there is no moral right in copyright law, as there is in other countries. There's a moral right to attribution and kind of a right of publicity sort of thing that you can have a say in how your work is used. Under U.S. law, that's not the case unless it's a large public work. Then there's the VARA Act, which they've kind of shoehorned that in to be able to fit in the Berne Convention. But there is no attribution, no right of publicity or attribution right for users. So she had to defend herself, had to sell her house in Vail, Colorado to defend herself, but she did end up prevailing on this, and it went to the Supreme Court, and we were hoping the Supreme Court would give us a really good fair use case on this, but the Supreme Court ended up saying the photograph is an option for a cover and the painting is an option for a cover. They're the same. So the commercial factor, it's used for a commercial work. We're going to say it's not fair that they chose this image over the other image. And so they kind of skirted the idea of whether attribution art was a fair use in the way that he created that. Now AI could create this very easily, right? So, but it wasn't the decision that we had hoped it would be on fair use and that, but it did tip the scales a little bit on the factor when we talk about what is the impact on the market. So there's a little bit more scrutiny there and how these outputs get used. So that's the reason that we would use that. She was cut out completely on the first one, but she was able to prevail and got her court case. She won the court case and the $10,000 plus the legal fees, right? But other than that, that wasn't a huge win for her either. I mean, it cost her about as much as she walked away with. So it wasn't, for her, it was not a great deal as a photographer, other than setting that precedent that, hey, maybe there's something to this. So Getty Images is the other one. This is a recreation of the original lawsuit image of Getty. This one, was made with the later versions of of Stability, and Getty Images sued because they say, hey, this image creator, I think it was Midjourney again, or no, Stability, had gone and eaten all of its stuff. And the original one you can see here, the original soccer player and the Getty Images watermark, even the AI partially created the watermark. And so they are suing, and they're currently, this case is not yet settled. So this is still an ongoing case from back in 2022, 2023. It did settle in the UK because they also sued them in the UK for images. And the UK said, yeah, the new models don't really reproduce. It was dilution of your trademark on the initial ones, but because the new versions aren't doing that, we can't really replicate it without really trying, then there's not as much harm. And it's not a copyright infringement because it's not an exact copy. There's enough nuance there, and one is terrible. That's why you can see that this one is much better, even has Harry Kane's face on the soccer player, which, you know, we could talk about digital replicas there too, right? But yeah, so this one's still pending. Is it copyright infringement? Is it not? Was it fair use for them to take the public-facing Getty Images that had the watermark on them that was there to protect from copyright infringement to have AI train on that content? The other big ones now, Midjourney has now gotten much better at and Stability, right? That AI has a Snoopy problem or a Shrek problem or a Darth Vader problem. And so Disney and Universal Studios are suing for copyright infringement of these outputs. And so there's probably the risk that starts hitting us, is because they're starting to sue users that use these things commercially as impacting their market. So one of the quotes, it's systematic plagiarism, and Midjourney is the quintessential copyright free rider in a bottomless pit of plagiarism. So you can see what their opinion of this is. And yet in the same breath, they license to Sora the use of some of their characters. So Disney has now licensed it, and I think it's to show that there's a licensing market out there. So there's the impact on my market, because look, we license to these people, just like the music studios that are also a big litigant in this AI thing, right? They're suing, but the original creators, how much credit are they getting? I don't know. So this one's still pending. Warner Brothers has also joined the lawsuit for the use of their characters and things like that. So it's kind of a mess right now. So, and part of that is, again, we talked about style, but it's the expression that gets created or protected, and not the style. Style in the United States is not protected. So as you can see, there's issues with that, right? The Studio Ghibli said, hey, wait a second, anybody can post my style of artwork. The Stormtrooper and the Starry Night, another example of that. You know, the style is not protectable, but to what extent? Where do we go from that? And so that kind of leads us into what are the things that we can do as educators to help us in our campus? What are the practical uses of this? And first, I would say just staying informed. Now, by staying informed, I don't mean you got to follow every copyright lawsuit that's out there, all 111 of them. Who has time for that? Nobody. Well, except for the people on ChatGPT is eating the world. They make it their thing to advertise those. But just kind of get a feel for it, get an idea of where are the risks, where are the gaps, what are the risks for our campuses and the things that we can do. So, and a lot of that is in the governance of that. So it's a governance issue because it's already in our systems, the things that AI does to enhance video or add captions or things like that. So what are the governance things? What are the vendors doing? What protections do we have? Because we're typically pretty well downstream from these lawsuits. And it's what's going on upstream, right, with these AI systems that are under the gun there. But where's that going to go as they run into roadblocks or slowness with the law and litigation? They're going to start looking for users that maybe don't have rights to this, much like they've done with music uses in social media. They'll decide, oh, this university, like USC, right, was sued. The lawsuit settled, but they were using music in their sports Instagram thing, and they didn't have a license for it, even though it was on as a creator profile on Instagram. They had access to wide library of music, but they thought, well, you guys are making a ton of money in your athletic department, so we want some of that too. And that's kind of some of the risks that we'll look at in the governance and the risk that is evaluated. So really, the takeaway is AI adoption without any kind of governance is going to cause issues. So hopefully your institutions are taking a look at some of these things. And I hope this has been informative, if nothing else, to what's kind of going on out there and what's happening. But I'm happy to take any questions or what ifs or scenarios that you have. So.
A dumb question. But I'm thinking sensitivity. I'm assuming you use AI to
I sure did, yeah. Yeah. Yeah, so yeah, that was Circus. There was the idea there, and there was some spelling errors in some of that because I created them a year or two ago. I think they do a lot better job now than they did then, but some of those original ones, some of them I couldn't even use because it just was gibberish. But but it was kind of fun to see that it could do a style of an old circus poster and that kind of thing. So it was kind of fun to create. But yeah, playing with the different things. Our campus has a couple of licenses that will protect our data and our IP, which is big. But one of the big issues I'm dealing with right now is with the vibe coding and people creating apps and using some of these AI tools to create applications and what can the university claim if it's a professor that's doing that? Is it even copyrightable? I mean, yeah, they can sell it and make money off of it, maybe, but can the university protect it from anyone else doing the same? Yes. Yeah. Uh-huh. Yeah. Yeah. To protect the university, you can cite it, and probably ethically, I should say, created with AI, or AI created some of the other examples that AI created, or I think Gemini, when you use Nano Banana, puts the little diamond thing on there. So that's probably sufficient to let someone know that that's where that has come from, just some kind of disclosure that way. But again, in terms of how much, it kind of depends on how obvious it is, like, kind of the plagiarism conversation, right? It's are we taking it as our own, or was it AI that did it? Sure.
So check with your state laws as well. So in Idaho, again, we don't
Mhm.
have a state policy. I said on my board, but we don't have a state policy on AI anytime soon, and so we really love to get these speakers. But there are states, especially in the West on the West Coast, who are making state laws
Yeah.
regarding that, and that is why you have to adopt that. And then the other thing that I would want to is, if you are using these in the classroom, and you're not citing them, know that that shows your students that they don't cite. And so I always caution.
Modeling.
On leading by example. And so if you're using this as a site, because you go to expect it to be cited. So it's kind of an activity from my perspective.
Yeah, yeah, good point.
Also, I wanted to, you see the new photograph.
Mhm. Yeah. It's, the video itself would probably be the AI generated, right? You'd have to disclaim that part of it. You could keep your own artwork, that part you could claim, and they would copyright that as an image, but they wouldn't copyright it as the motion picture, the video. Trying to think which category they use on that, but it's different than the still photograph. But yeah, because unless you had some control of what it was doing there, but if it just animated the wind blowing through the trees, like on the painting behind you, you know, that would probably not be protectable, but the painting itself would be. So good question though. Other questions? All right, sounds like the lunch is brewing. I don't want to keep anybody from lunch, so I appreciate your participation, and hopefully you came away with something good out of the presentation. If you have questions, my contact info is there, and I'm happy to always geek out about this kind of stuff, so feel free to reach out. Thank you.